Well, good morning, everybody. It is quite early for me, actually. This is only 20, coming up for 20 to 11 in the morning. But I've been up since I was hauled out of bed first thing this morning and taken on a long walk. So if I've got to suffer, anyway, stayed up late last night to watch the trial 4. Very interesting. I must admit, I found it obviously so many parallels to Stephen's case, in particular Steve, of course. But yeah, what an amazing amount of cognitive dissonance from the two ex-police trying to say everything's fine. There's nothing to, this case is as clean as it comes. It's like, who are you trying to kid? Both my eyes are wide open and I can see exactly. We did have a laugh at the mention of the one-eyed Mr. C. I said, no, that's not me. That's not me. Anyway, digressing. Let's get on to the serious business of what. First of all, let's have a look and see. Some of you might not be aware of the fact that this document exists. This was filed June the 14th, 2018. So we're talking nearly 2.5 years ago, aren't we? 2 years, 5 months ago. This is defendant's motion for substitution of judge. Defendant Stephen Avery, by his undersigned attorneys, respectfully moves for a substitution of judge pursuant to Wisconsin Statute 80158. In support thereof, Steve states as following: on October the 3rd, 2007, Judge Superwitch dismissed Steve's motion for post-conviction relief. On November the 17th, Steve filed a notion of appeal from Judge Superwitch's October the 3rd, 2017 order. On November the 28th, 2017, Judge Angie denied Steve's motion for reconsideration and supplements thereto. On November the 30th, 2017, Mr. Avery filed a notice of appeal from Judge Superwitch's November 28th, 2017 order. On May 18th, 2018, Mr. Avery filed with the Court of Appeals a motion to supplement the record on appeal with a CD disclosed to the state by the state to Steve during the pendency of the appeal. In the motion to supplement, Steve alleged that a Brady violation when the state failed to disclose a CD which contained images and an analysis of the images and information obtained after the DAS's computer was seized and analyzed. Mr. Avery contends that the suppressed evidence on the CD is exculpatory and or impeaching, and Mr. Avery was prejudiced because the evidence is material to his guilt or punishment under this under a Brady violation. Just want to make sure everything's working as it should do. Just bear with me one moment. Check this. Yep, everything seems to be working fine. On May 25th, 2018, the state filed a response in opposition to the motion to supplement. On May 29th, Steve filed a reply in support of the motion. On June 7th, 2018, the Court of Appeals entered an order denying the motion to supplement and remanding the case to the Circuit Court for further proceedings. In pertinent part, the order states as follows: based on the assertion that Avery recently received previously withheld discovery or other new information, We retain jurisdiction but remand this case to enable Steve to file an appropriate supplemental post-conviction motion in the Circuit Court. Avery shall file any supplemental post-conviction motion within 30 days of the date of this order. The Circuit Court shall hold proceedings on the supplemental post-conviction motion and enter its written findings and conclusions, deciding the supplemental post-conviction motion within 60 days after the motion is filed. See copy of order. The rules of civil procedure apply to Steve's post-conviction proceedings. See Wisconsin Statute 97406. Proceedings under this section shall be considered civil in nature. Wisconsin Statute 97211. The rules of evidence and practice in civil actions shall be applicable in all criminal proceedings unless the context of a section or rule manifestly requires a different construction. The rule of civil proceeding governing the substitution of judge, Wisconsin Statute 801-58, provides as follows. Any party to a civil action or proceeding may file a written request signed personally or by his attorney with the clerk of court for a substitution of a new judge for the judge assigned to the case. If, upon an appeal from a judgment or order, or upon a writ of error, the appellate court orders a new trial or reverses or modifies the judgment or order as to any or all of the parties in a manner such that further proceedings in the trial court are necessary, any party may file a request under subsection 1 within 20 days after the filing of the remitter in the trial court, whether or not another request was filed prior to the time the appeal or writ of error was taken. The remitter was filed in this court on June 11, 2018. This motion is filed within 20 days of the date the remitter was filed. Mr. Avery's motion is therefore timely. Mr. Avery's motion is also proper, as the statute provides that he has an unqualified right to substitution of judge under these circumstances. State ex rel. Findhoff and Sons. Circuit Court for Milwaukee County 2000. In Findhoff, the trial court ruled against the defendant in a breach of contract action and awarded the plaintiff special damages. On appeal, the Court of Appeals held that the trial court erred when it failed to make factual findings to entitle the plaintiff to recover future lost profits. The court remanded the case with a directive for the Circuit Court to make detailed factual findings and determine whether the facts supported an award of consequential damages. On remand, the defendant, Findhoff, moved for a substitution of judge under Wisconsin Statute 801. The chief judge denied the substitution. So it was down to the chief judge. In doing so, the chief judge commented that reassigning the case would be basically the same as ordering a completely new trial. He concluded that the right of substitution did not attach because the Court of Appeals gave directives that were very specific and did not call for a new trial. Findhoff filed a petition for supervisory relief with the Court of Appeals. The Court of Appeals denied the motion. In doing so, it held that the right to substitution exists when the case is remanded for a new trial or for proceedings other than specific action. The court concluded that the remand order required specific action. It reached that conclusion because no new evidence or facts needed to be elicited for the trial court to comply with the mandate. On further appeal, the Wisconsin Supreme Court noted that following remand and remitter, a circuit court may conduct three types of proceedings. 1, a proceeding in which a circuit court takes specific actions as ordered by the higher court. 2, a proceeding in which a circuit court conducts a new trial. Or 3, any further proceedings other than those mentioned above. If the mandate calls for further proceedings as contemplated by Wisconsin Statute 808, the parties have a right to substitution upon request. If the mandate calls for specific action, then there is no right of substitution. The Wisconsin Supreme Court narrowly defined specific action as a purely ministerial duty requiring no exercise of discretion on the part of the circuit court. Conversely, the court broadly defined further proceedings to include any situation in which the circuit court may exercise its discretion in discharging its duties on remand. The court based its ruling in part on the wide purview of the substitution statute, which suggests it should be liberally construed to permit substitutions, as well as Wisconsin's long heritage of upholding the right to substitution. The Wisconsin Supreme Court concluded that the mandate at issue directed the circuit court to undertake further proceedings to which the right of substitution attached. Namely, the order required the circuit court to make factual findings and determine whether the facts supported an award. The court held that the directive required the circuit court to make an evaluation which required the exercise of discretion. Thus, Findor's motion for substitution was improperly denied. In this case, the Court of Appeal's directive on remand requires the circuit court to evaluate Mr. Avery's supplemental post-conviction motion and enter written findings and conclusions. The order contemplates that the circuit court may grant or deny Steve's supplemental motion. In short, the order grants the circuit court unfettered discretion to resolve the merits of Mr. Avery's supplemental post-conviction claims, which may grant him the relief he is seeking and result in the dismissal of the pending appeal. Because the appellate court's orders requires the circuit court to exercise its discretion in discharging its duties on remand, the mandate requires further proceedings to which the unqualified right of substitution attaches. Moreover, for the convenience of the judiciary, the parties and witnesses, Mr. Avery respectfully requests that his case be reassigned to a judge in Manitowoc County. Because at the moment, of course, Judge Angie, Superwitch, is one of 5 branch judges in Sheboygan. The record, evidence, and many of the witnesses in this matter are located in Manitowoc. All pleadings are filed with the court clerk of the circuit court in Manitowoc. In short, at this juncture, holding further proceedings in Manitowoc before a Manitowoc judge would be the most efficient use of judicial resources. At this juncture, in Steve's case, all of the prior reasons for holding the legal proceedings outside of Manitowoc no longer exist. Wherefore, for the reasons stated herein, Steve respectfully requests a substitution of judge in accordance with Wisconsin Statute 801. Now, obviously, we've not had a change of judge yet. Seems to be a lot of wasted space here. Oh, there we go. Look. Oh, here we go. Here we go. That's to do with the supplement the record with a compact disc. So this is referring to the evidence. And that's quite nice because it's got all the further ordered by Paul Bailey. And he did seem to be a little irritated, shall we say, with Judge Angie's awkwardness. Okay, let's come back then to, well, who are, hi Paul Ward, who are the judges in Manitowoc? Let's have a look at them first of all. We have Circuit Court Branch 1, none other than Honourable. I would question that. I thought he looked decidedly dodgy in his deposition and could not explain why the phone call the 95 phone call was never mentioned in their report that they took to peg likes a lager. So no, I don't go with Honourable Mark R. Roher, good friend of Mickey G, Michael Griesbach. And I don't think any of us would trust either of them as far as we could throw them. And there has been, a lot of people have said that he would most likely not be, he would either recuse himself or he would be prohibited as a conflict of interest. But as we know, it's all well and good saying the words conflict of interest, Mark Roher, but when that clearly doesn't happen and you allow your sheriffs to march all over the case, all over the investigation, then we see what kind of mess you end up with. So hopefully it won't go to Mark Roher, which leaves us only two other judges, the Honourable Geraldine and the Honourable Robert. And I did want to find out a little bit more about additional circuit court branches. What do we mean by these different branches? And what I discovered was that basically they don't do anything different. It's just the fact that they call them branches. And it says here about the fact that additional circuit court branches, by November the 14th, 2020, the Director of State Courts may add 4 additional circuit court branches to begin operation on August 1st, 2021. The Director of State Courts may allocate each branch to any county that the Director of State Courts determines is in need of an additional circuit court branch. If the county has passed a resolution requesting an additional circuit court branch and the county has established or will have established by May 31st, 2021, the appropriate infrastructure to support an additional circuit court branch, the Director of State Courts may require any county as a condition for receiving a circuit court branch allocation under this subsection to have established or to apply for a grant to establish a drug court. Now, I did see somewhere that the annual budget for the courts in Wisconsin, it was something, just the budget for the judges was something like 300 million, or maybe that was for everything. But anyway, we're talking about quite a bit of money, and obviously it's a case of, a county has, like Manitrock has 3 judges, it can apply to have a 4th judge so that they've got, the ability, presumably, to hear more cases and to establish a specific drug court. What have we got here? Court branch judge. In each judicial circuit, each judgeship shall be given a branch number. Each branch constitutes a circuit court with all the powers and jurisdictions possessed by circuit court in circuits having 1 judge only. In other words, you add a 2nd judge, they're exactly the same as the first one, and may be designated in all papers and proceedings either by its respective number or by the name of its presiding judge. The chief judge of the first judicial administrative district shall designate 2 circuit court branches that will primarily handle cases that involve a violation of CH 961 involving a controlled substance included in schedule. Okay, so this is obviously to do with the drugs. The chief judge of the first judicial administrative district is authorized to designate 4 circuit court branches to preliminary handle violent crime cases that involve a violation of. If a felony is committed while armed, and if the circuit court branches are designated under this subsection, 2 shall begin to primarily handle violent crime cases on September the 1st, etc. Okay, so I don't think we're getting much more information there. This I found interesting. Criminal Intake Court. This is Manitrock here, Manitrock County's website. Criminal Intake Court is held on Monday afternoons. Felony cases or cases involving defendants in custody are heard commencing at 1:30, followed by misdemeanor cases commencing at approximately 2:30, starting on the 17th of September 2020 through to the end of 2020, in an effort to control the number of individuals who have to be present in the courthouse. Criminal intake is being split out into 2 separate days, with criminal felony intake being held on Monday afternoons before the intake judge, and criminal misdemeanor intake being held on Thursday commencing before Commissioner Pat Copper. Now, the judges are on a monthly rotation for intake. The branch 1 judge presides over intake for January, April, July and October. The branch 2 presides over intake for February, May, August, November. The branch 3 judge presides over intake for March, June, September and December. Okay, so it seems to me quite clear that these branches, they don't mean anything other than the fact that you can have 1 judge, you can have 2, you can have 3. Sheboygan has 5, Manitrock has 3. We've got branch 1, Roher Bart, branch 2, Geraldine, branch 3, Robert Dwayne. Okay, so let's see if we can find out anything at all about some of these particular individuals. Let's go with Bob Dwayne. Let's fire up to the top here. Bob Dwayne is a branch 3 judge on the Manitrock County Circuit Court in Wisconsin. Dwayne won the seat in the general election on April 14th, 2017. Dwayne was a 2013 candidate for the Manitrock County Circuit Court, branch 1 in Manitrock County, Wisconsin. He ran unsuccessfully in 2012 for a judgeship in branch 2. So he's quite keen to get himself to be a judge. Typically, we have somebody who earned his BA from Marquette University in '94 and his JD from Marquette University Law School in 1999. Elections. Notice Patricia Copper was one of the ones that was mentioned as the commissioner. But this is what I found interesting. Bob Dwayne in 2017 beat Patricia Copper and Donald Tuning. Can anybody remember who Donald Tuning is? We have looked at this person before. Donald Tuning was the lawyer that Dean and Jerry arranged for Jody Stokowski and was engaged in 1 or 2 heated emails, received some very angry emails from Ken Kratz. We have been through that. So that was Donald Tuning. So it's interesting when certain names crop up. Not that that makes any difference here. He didn't get many votes at all. Compared with the 48% of votes that Bob Dwayne managed to secure. Next, let's have a look at Geraldine Dietz, or Dietz. I'm not too sure what her her name is. Dites for judge. Geraldine Dites for circuit court judge. Okay, endorsements for her. Judges that have endorsed her. Circuit Court Judge Angela Superwitch. Couple of sheriffs. Prosecutors. Look who appears on this list here. None other than Douglas Jones. And we've heard about him, haven't we? And his email with Cochet about that very matter of the 95 phone call. I don't think there's anybody else here that struck out. I say it doesn't mean anything if Douglas Jones is one of the prosecutors that has endorsed Geraldine. It's interesting seeing these names crop up. What have we got here? Oh yes, yes. So here we go. Here's a full-on picture of Geraldine. So this could be the Manitrop judge that Steve's comes before. And this audio clip obviously doesn't play, but anyway, the Honourable Gary Bendix, who was one of the previous judges, administers the oath to his successor, Geraldine Dites, yesterday, as she becomes the first female circuit court judge in the history of Manitowoc County. Oh well. Dites defeated attorney Ralph. These Polish names, incredible, aren't they? I mean, you've got all of these letters, you know, these are consonants, and you've just got two vowels. Luckily, I think because of my knowledge of Polish speedway riding, I think that's Ralph Cegielski, but I could be wrong there. But what do we know about Ralph Cegielski? Well, quite a bit. We know a lot about Ralph Cegielski. Kaczynski to represent Dassey. This is from March the 9th, 2006. The Appleton attorney who will represent a teenager charged in the Teresa Hallback homicide said Wednesday a plea deal is possible for his client. Certainly it's a possibility depending on the circumstances surrounding the taking of the statement, whether that is challengeable or not, said Len, who was appointed this week to represent Brendan Dassey of rural Mishicot. But that plea, Kaczynski said, depends on what the special prosecutor offers. Calumet County District Attorney Ken Sweaty Prize Kratz, soon to be disgraced, declined comment Wednesday on a possible plea. I haven't had any discussions with Len yet, so it is premature. Kaczynski, an Appleton attorney, was appointed to represent Dassey on charges the teen participated in the sexual assault and slaying of Hallback. The appointment came Tuesday from the Office of the State Public Defender and was signed by Manitowoc County Circuit Judge Jerome Fox, who is presiding in the case. The first attorney appointed to represent Dassey, Ralph Cegelski of Manitrock, withdrew hours after Dassey's initial court appearance Friday after learning he was a distant relative of Holbach. So, we know about Ralph Cegelski. Let me just do this one moment. Just want to quickly look at something, which hopefully will allow me to no. Sorry about that. Okay. Is this the same Ralph that had to bow out of representing Brendan Dassey because of his relation to Teresa Holbach? Was a question by the Snake Estate on Reddit. And somebody that goes by the name of the Dong Song. Yeah. He represented Brendan long enough to waive the preliminary hearing, and then suddenly he remembered he was related to the victim's family. Hard to believe that the guy didn't remember he was related to the Holbachs during the 6+ months of unprecedented media coverage of the biggest investigation to ever take place in Wisconsin. This guy has mostly been overlooked, but he played a crucial role in sabotaging Brendan Dassey's defense. Well, nice to see that Ralph was unsuccessful in trying to get himself a place on the Manitrock judge. Let me just have a look and see if I got. Okay, I was having a look to see if I got any pictures of Bob Duane. What have we got here? I think that was just the Ballotpedia thing. Let me see if I can find you a picture of Bob Duane. Let me see if I can do this. Let me go to here. Do a bit of this. So if I come back to here and I click on this one here, and then I click on this one here, here we go. Here's Bob Duane when he was candidate for Manitou County Circuit Judge. 10 following, 11 followers. Well, my boss was elected judge, and now I'm in the process of seeking the appointment for his old job as district judge. That's a shame that nobody's clicked on like there. I posted a new photo on Facebook. Nah, sorry. On the Herald Times website, they have a poll question regarding February 19th primary. Head over and vote for Bob. Oh dear. Don't forget about the candidate forum at Manitrock City Hall this Thursday night. Oh dear. Not to worry, Bob. You made it there anyway. So, you know, listen, I don't know how good or bad his politics are. He is now potentially the judge of one of the, well, what would be, it was at the time, back in 05, 06, 07, back in 07, it was the biggest case in Wisconsin history. You know, he could be the judge facing the biggest case in American history. Wouldn't that be something for you, Bob? Good on you, Bob. Okay, that was Geraldine. We've done the endorsements. We've done Kaczynski. Yep, I think we've more or less covered everything that I wanted to about. Yeah, I think that's just about it. Let's come back up here. So let's just turn that to there. Obviously, one of the thoughts that struck me was the fact that if Kathleen Zellner hadn't have filed that motion for a substitution of judge, it would possibly have been used against her in the sense that, you know, well, if you felt that badly about this judge and you're kicking up such a fuss about her, strange that you never applied for a substitution. Whether or not that was ever likely to happen or not, I don't know. But it will be interesting to see, won't it, if when the Court of Appeals, Paul Riley, who clearly has a problem, has had problems with circuit judges before, as we saw with that other circuit judge in Sheboygan, when he was trying to act like a prosecutor, Daniel Borowski, that we looked at last time. Yeah, we're just going to have to wait and see what happens on that. You know, sometimes you have to be careful what you wish for. You know, maybe Judge Angie is just like all the other judges. Certainly Daniel Borowski and Angie seem to be the same. As I say, Mark Roher has a terrible record in this case. Looked dodgy as hell in depositions. Embarrassed to be there. Totally embarrassed to be there. Says that they are handing over the case due to the conflict of interest, and then does absolutely nothing to prevent huge conflicts of interest. So it makes you wonder just what all the judges are like, and certainly some of them are despicable, aren't they? You know. Anyway, really, that's all I wanted to go through today. So tomorrow morning, hopefully, as I say, Dr. Siltman will have recovered from his hangover, and will be able to join us tomorrow morning, usual time, my 11 o'clock. Hopefully, Mill Billy, if he now knows what he's doing this week, likewise. Let's just see who's all here. Hi, Big Dog, and hi, Sean, Jaznaz. Hi there, everybody. Let's see what we've got. Oh, Jennifer. Hi, Jennifer. And as I say, Paul. Hi there. Okay, I think we've covered everything on that front. So as I say, tomorrow we'll have a chat with hopefully Mill Billy and Dr. Siltman, and see if Mark is able to join us as well. And then I will get back to looking at the strengthening forensic science. We really want to get back into that, into that report. And as I said yesterday, had some positive communication with Marty Tadcliffe. So if I can get that set up, that would be absolutely brilliant. Also, somebody got in touch with me to say that there's another guilter on a Facebook page that's want to come on and I don't know, debate, give us a load of cognitive dissonance, which would be absolutely brilliant, if only for entertainment value, because it looks as if Bose is. I haven't heard from him for over a week now. There was a slight problem to begin with, in that one of his emails back to me went to the junk, but I found it and then sent him a couple more emails, and he sent me one which I'm looking forward to disclosing tomorrow if Millbill is here, because it just smacks of the kind of consonant cognitive dissonance that you get. That's so bizarre. Anyway, and then December, that's when Mark Godsey of Blind Injustice said, catch up with me during the holidays, and as did Charlie Burns. So you never know who might be coming on and when. Anyway, catch you all again soon. Thank you all for tuning in. As usual, pop your comments below. Who do you think, out of the ones that we've looked at so far, who would you be happy to have as the judge? Certainly, Rebecca Persick, I think it was Persick. She certainly had some good words to say, but we'll just have to wait and see. We'll catch you all soon. Bye for now.